Welcome back to Court TV Live, along with Julia Janae and Ted Rollins. Let's head back to Michigan now. We've been watching the closing arguments in the birthday party murder trial.
This case all began in April of 2024. Marshella Chidester crashed into a building south of Detroit, killing 2 young kids who were inside celebrating a birthday. There were more than a dozen others who were injured. She was charged with second-degree murder, 2 counts. So let's go back into court now. We're listening to what her defense is going to say to this jury to try and convince them to find her not guilty.
This is the law in Michigan says that the plaintiff, the prosecution, has the burden of proof. That's why they get to go first. That's why the defense goes second, because they don't have to prove anything. These people have to prove everything, every element beyond a reasonable doubt. And then because they have such a high burden to prove their case, they get to go first for a closing argument, that's what this is called. And then I do my closing argument as a defense. And then because they have such a high burden of beyond a reasonable doubt, they get to go again. They get to go last. So, and it's sort of common sense, we can't keep going on and on for many days. So they stop it there, the law. So they get to go first, then we go, and then they get to have closing argument the last. And sometimes what happens is that they'll do their closing argument and then they'll say something that I can't rebut or I can't stand up and talk like I am right now I'm going to be doing with what they mentioned. So I ask all of you, when you go into the jury room to deliberate, think about what Bill Colovos would have said. Think of how I would have countered anything if they're holding anything for their last time to talk to you and I have to just sit there. This case, I don't have to tell you, it's very, very, it's very sad. It's very, very sad. And the facts of 2 children passing away, as the prosecutor said, in a setting like this is just beyond grief. And that's why I took a moment out, maybe took my attorney jacket off, so to speak, and really gave sympathy to Mom. I give sympathy to all of them. I don't want anybody hurt. I don't have vindictiveness. My client doesn't. And I gave my sympathy. And it's normally out of line to do that. And I'm glad the judge and prosecutor allowed me for a minute to do that because I just had to get that off my chest or myself because I can't talk to the witnesses here when we're in court. And they don't have to talk to me at all. It's very, very sad. And, you know, I'm taking a little bit longer in a closing argument today than I normally do when I have a trial or I'm involved in a trial. Because there are several counts. Well, first, all due respect to everybody injured and the poor little kids. I want to show them respect. And that's why I want to just talk to you. I'm not making things up. You know, so many times, you know, attorneys, people raise their eyes or look up when you say attorney or attorney jokes and that. There ain't no joke in here. And I'm a real deal. When I talk to you, I'm not making anything up. Certainly, it's up to you. You're collectively the judge of the facts, all of you. And I respect that, and my client respects that. That's our American jurisprudence, our American law, is that we have, if you're charged with a felony, especially a capital felony, 12 jurors decide the case. So the judge certainly has been very nice and will release one person, or the clerk will. And then the 12 of you, whomever you may be, will deliberate and rule on the case as a judge of facts. Of course, the most serious part of this case is second-degree murder. Murder charge don't get no no more serious than that, at least in Michigan. A murder charge. And to me, in the law, is that for somebody can get charged every day for whatever. Somebody to be convicted of murder, whether it be second-degree murder, there's an intent. There has to be an intent or intentional, like recklessness. To me, that's intent. Okay? If I'm driving down the street on the freeway and Bill Colovos never had a heart attack and I have a heart attack and somebody's changing their tire and my car hits them, they die. There's not much intent there. I had a heart attack. What do you want me to do? I apologize. Everything that happened, but please don't charge me with murder. Okay? And that's our first part, are the poor 2 children that died. And my client, actions speak louder than words. My client, the officer says, in effect, had no record, no nothing.
Objection, Judge. I think he's arguing facts, not evidence.
Well, I thought I asked the officer with regard to record. If I didn't, the jury heard me not ask him that.
All right, we'll allow it, but it's a close call.
Thank you. This person doesn't drive around committing crimes. Here's this person that went to lunch. Let me back up. I want to address everything they brought up. But it's interesting that some of the things they brought up was not what they call a case in chief. In other words, when you present a case, as prosecutor, you put everything up there. Then the defense puts, if there's any evidence they want or whatever to counter it or bolster their defense, then they go up there. That's how it's done. Then they waited and did some rebuttal and pulled things out of wherever. Why did they bring that in case in chief? If it's so true and so positive. Something to think about. Is it lawful? Yes, they can do that in rebuttal. But think about common sense. That's another thing. You don't, a lot of times judges will tell juries, you don't leave your common sense outside. You leave your bias and prejudice outside, but not your common sense. It's just, you can have your common sense when you're in the room. That's what we all have, our life histories that we bring. That's why I like to have a little bit older jurors, because they've experienced life histories. And they can judge things because they've lived some life. And you can use that. You just can't have prejudice or bias. You can't have that. Somebody sitting at a defense table, they're guilty. Prosecutor, my brother, I don't like prosecutors and police. No, you can't do that. You got to start with a clean slate. Just as if somebody, anybody, family member, whatever, is being charged with something. You want them to have just a fair, clean slate you start with. That's why I asked in the very beginning, there's nothing been said, how would you find the person? Sometimes people say, well, they're charged guilty. No, not in America. They haven't put any proofs on it. They got to prove their case beyond a reasonable doubt, every element. With regard to going, and they held for rebuttal, this Fermi 3 or whatever party store, corner store, and there's this, she bought some stuff for the house, some wine and these 4 little bottles of whatever, Sutter or whatever. There's nothing illegal about that. When she went in there, I asked, is she sober? Is she okay? Yes. Would you sell to somebody under influence? No, thank God. I like to hear that. And okay, so we've got that they brought. And then we've got her going at 11 o'clock to Furnace Tavern. Okay. Did she drive there okay? Yes. Did she have an accident? She turned the corner. go down the road, country road, veer to the right, everything go okay? Looks like it did, or else the officers would be telling us. They're telling us anything. They went and looked at something she bought at 9 o'clock or 9:05 in the morning. So, okay. So if it doesn't exist, that's a positive for my client. Remember that. They're going to bring up every negative there could be with a microscope. That's why there's 2 attorneys in the room. And we're going to bring up positive or...
2 attorneys, they're bringing up 2 different looks at Marshella Chidester.
Yeah, they keep bringing up this, her crashing the car and then keep going and
continuing to drive. I don't think there's much that the defense can say to turn that around. That is a powerful piece of evidence for the prosecution. Let's get to a break. We'll get you back in for more of the defense closing arguments on behalf of Marshella Chidester.
Grieving widow or mastermind behind a murder.
Monica Cementelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cementelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story, but will there be a twist that no one sees?
The celebrity stylist murder trial, today, only on Court TV.
Back to Michigan we go. We've been watching the closing arguments in the case against Marshella Chidester, the birthday party murder trial, where in April of 2024 in South Detroit, she plowed into a boat club, killing 2 kids who were inside, 2 small kids, a brother and a sister. And the state says she was intoxicated at the time of the crash. Her attorneys say she was having a seizure and that the breathalyzer test is wrong.
Jack Rice, we've heard the beginning of the defense close, maybe a little tone deaf. I don't know. What's your take, and what does he need to do to maybe get one juror to think?
Yeah, all he really has is burden of proof. And the problem is the state has proof beyond that reasonable doubt, and it's quite obvious. You know, sometimes there's an old adage, you argue the law if you have the law, you argue the facts if you have the facts, and if you don't, I guess you wave your arms a lot and dance. I'm not really sure, because in a case like this, I think we come back to the question, why are we all here? Because the state really has a very airtight case, and they just dropped it in the jury box, and there's nowhere else to look.
So true. We are going to go back inside the courtroom. I do want to clarify, I mentioned the breathalyzer. It was a blood test. They didn't do a breathalyzer in this case. So let's listen to how the defense handles it. They've been very open with this jury, saying they know there are bad facts, but that they should use their common sense.
So, okay, so then she drove at about 11 o'clock to Vernus to meet 2 friends for lunch. She says a sandwich. They say no. Sandwich, you'll see the receipt as an exhibit. Take a look at it. Looks like my client had a better memory on the food part. And so she had the chicken chili or whatever. And she also had 1 glass of wine. And Verna, the person, Kelly Thornton, that came here, and I'm told that she's like really a peppy person, but she was very sick that day, and you know, and it showed. She did not feel good, and I'm glad she showed under subpoena. And she testified that she was sober. When she came in, she was sober. So if the prosecution is trying to say that she guzzled all these drinks and then went in there, you're wrong. Actions speak louder than words. You can talk all day long. Prosecution wasn't there. The police weren't there. All they're doing is surmising. And they're trying to surmise beyond a reasonable doubt. And they're trying to throw out facts like these 2 children passed away at a party. Absolutely. I feel horrible. That doesn't make somebody automatically guilty. You have to prove it. We don't go by emotions. So she comes in. The testimony of Kelly Thornton is she's sober when she comes in. It's just normal. She met friends, had lunch, had 1 glass of wine. Any other wine? No. Anything else to drink? Water. Okay? And the bill, she got the bill. They each got individual bills, whatever was paid by a credit card. Thank God there's a record of it. Exactly what my client said. And when I first met my client, she said I had one glass of wine, Bill, at Verna's when we were at Verna's, because I said, what did you have at Verna's? She said, one glass of wine. And you know, as a defense attorney, you sort of, you listen to clients, but until it's backed up with something, either paper or something, you don't automatically, I hear it. I keep it in my head, I hear it. And then, when I see the search warrant that they immediately used, closed it off, nobody allowed in, immediately, because she told them, I went to Verna's, where were you before? Verna's. They went there, they use a search warrant immediately, and they get the receipt. And you'll see that's one of my exhibits. I only have like 3 exhibits, A, B, and C. I keep it simple. And that's one of the exhibits. If you take a look at the defense exhibits, got a little delta or a D in law school, that's what we use. And so that lines up perfect. She's trained, she said, for 20 years. She has regarding alcohol and looking, observing, and the effects of alcohol and seeing if somebody might be under the influence, not to serve them. And she didn't. And she felt she was totally fine. When she left, was she fine? Okay. What did she buy? What did she drink extra? Nothing. Okay. So we know that's solid. We know that before 11, it's solid sober. Then we know at 12:15 when she left, solid sober. In America, in Michigan, you're allowed to have a glass of wine. You're allowed to have a glass of wine. And she ate. Okay? And she just miraculously was able to drive home and go through the country road and Branshaw and turn and take the angle and do all that and not get stopped, not have a collision, not fall off the road and go into, you know, areas that are not the paved road. And she was able to park her car. These are all things of sobriety. That's what we look at. Wasn't parked on an angle. She didn't hit people coming home, hit people, the neighbor. So then...
We're hitting the pause button on these arguments by the defense. You're not going to miss a moment. We will have more of the birthday party murder trial from Marshella Chidester happening in Michigan after this. Stay with us. Welcome back to Court TV Live. I'm Julia Janae along with Ted Rollins. Thank you for being with us and following along as we track several trials and cases across the country. We're in Michigan bringing you closing arguments in the birthday party murder trial for Marshella Chidester. She's accused of driving her car into a boat club that eventually killed 2 children at a birthday party.
In Iowa, the murder trial for defendant Christopher B. Hall continues. He's accused of stabbing his girlfriend to death.
And in California, the prosecution's star witness, a co-defendant, Christopher Austin, is back on the stand for a 3rd day in the celebrity stylist murder trial for Monica Cementelli.
Let's start with the birthday party murder trial for Marshella Chidester. We are watching the closing arguments. We're going to pick up the defense close in just a minute, but first let's check in with Court TV legal correspondent Kelly Craig. Kelly, busy day there in that Michigan case. The defense, put on their case. They had the expert on, then the rebuttal, and those videos, a lot to talk about.
So much to talk about here, Ted. Good afternoon to you, as well as Julie and everyone else watching. This has been such a heartbreaking case to watch out of Michigan. So I want to talk a little bit about that rebuttal case from the state, because defense counsel, during his close, you've heard him mention it, and talk about how during the state's case in chief, they didn't bring in that evidence. So it's not that strong. That's what he was telling to the jury. Now, in the rebuttal, eventually you're going to hear from the state, who delivers a rebuttal close in which they're going to address that comment made by defense counsel and going to talk about how, we were putting forth this evidence in rebuttal to rebut what defense counsel put on in his case. And that was talking about whether she was drunk or not, and talked about that 1.8 BAC. Why don't we go ahead and play a little bit of some highlights from this rebuttal case from the state.
April 4th, 2024.
And what time was this transaction made?
9:01.
So 1 minute after you opened?
Yes, sir.
All right. And what is on that receipt?
It is a 4-pack of Sutter Home Pinot Grigio wine and Sovereign Cabernet, a bottle of wine.
When you say a 4-pack of Pinot Grigio, just a few questions about that. What is Pinot Grigio? I mean, I know it's a wine. Is it a red wine, a white wine?
It is I would say a white wine. It's clear in color.
Clear in color, okay.
Yes, sir.
A 4-pack is, what size approximately would those bottles be?
Honestly, so it's 187 ml. It's a really small bottle of wine.
Okay, so that was part of that rebuttal case. And I believe we have another video we can show you as well that they put forth during that rebuttal case. This is going to be some surveillance video from inside the kitchen of the defendant, in which you see her with some bottles, or eventually carrying a little bottle of wine. Yes, you can see it right there. And so defense, what they are saying in their case is that that 1.8 BAC, that was inaccurate. They brought an expert to the stand saying that that's not accurate. So in the rebuttal, the state is putting forth all this evidence, trying to show, actually, we can infer from all of this video here and that receipt that she did drink a lot that day, more than just that one glass of wine that she is saying. Ted and Julia.
Yeah, circumstantial evidence. They can connect the dots as a jury. I want to talk to you, though, about what's most important in this case, and that's those 2 little kids who lost their lives. And I understand that recently their father did an interview about this case. What can you tell us?
Yeah, Julia, so sad and heartbreaking to hear what he has to say. This is the father, Brian Phillips, of the 2 little kids who tragically lost their lives. You're taking a look at them right now, Zane as well as Alana. Let's listen to a bit of that interview he did.
We buried them 3 days before his 5th birthday. So basically, collectively, me, Jaden has been everyone just adjusting without them. And basically, daily has been hard because they're, during the weekends, the weekdays, I'll talk to my daughter all the time. My son, he was just learning FaceTime. He didn't even know how to work a phone. He was learning it. Alana, she was learning basketball. I played basketball for like Wyandotte, Detroit, all through Taylor. That's what I do. And she was just learning the sport. She would go with me to learn the game. And last Saturday, before they passed away, she just went to the basketball game.
Brian was saying during that interview that he didn't come out and talk at first just because he was so heartbroken, and then he started to see all of this focus and attention on the defendant, and he wanted to come out and talk about his children and wanted to make sure no one ever forgot them.
Yeah, it's heartbreaking to hear him. And that interview in its entirety is really heartbreaking. I mean, he spent so much time at the grave, and you can just see how this has ripped these families apart. And this community, a small community outside Detroit. Kelly, thank you. Let's go back now. Pick up the closing arguments. When we left off, it was the defense attorney addressing the jury, and he's basically ticking off things that the prosecution has showed them. He hasn't addressed the video, though, from their rebuttal. That's where we left off. Let's get in.
Gets home. She's home for a couple hours, let's say 12:15. She goes up to the birthday party at 3:02 or thereabouts. She was leaving 3:01 in the afternoon. So 12:30, 1:30, 2:30, about 2.5 hours. Then they say their proofs, well, and they wait that video. They wait until rebuttal, not their case in chief. So I don't know what was in their mind. That's up to you. I don't know if they thought that maybe it's not as strong or doesn't make sense, but they waited till rebuttal. That's up to you. That's your area. That's your bailiwick. Okay? It's all about credibility. And so that's when they bring up and say, well, look at what we found. Look at what, we got a video here. Let's call, the officer back up here and talk about a video that shows that she's walking around, okay? She's got that, whatever. And, maybe she's drinking, okay? All right? And then she's not falling down. She's not tripping. She's not dropping things. But, maybe she's under the influence. Well, maybes don't convict. Maybes not beyond a reasonable doubt. We don't do that here in America, maybes. We don't send somebody away. Murder, too. Maybe. Okay? So then, this collision happens. And you say, you know what? That was just crazy. Okay? You're right. It was crazy and completely out of character that somebody's never had anything. And that makes me think that something neurological, that there's been talk, and that she went back while driving out of the driveway and went in reverse. She hit, and then hitting the arm came back and went full speed ahead. And they're saying, the prosecution for a murder too, that she intentionally did this, that she had this intent, this reckless intent to kill somebody. Okay? Former Commodore. Reckless intent to kill someone. I swear, and I swear, there's no intent to kill anybody, much less two little kids. There's no intent to hurt anybody. Why would you put it to the floor? Why would that person testify that it's brake and gas for a second there? Both. Where'd that come from? So, you know, when I'm working on this, I put a lot of days and hours in it. When I'm working on this at my office, you know, I'm looking at just, it don't make sense. Out of nowhere, somebody's going to put it to the floor. Somebody's going to put it to the floor and go right into a building that's 450 feet from her house. She's a former Commodore. She lives on the street. Lived on the street forever, married, you know, whatever, long time. So they're...
That bad equipment that Judge Nichols says.
Good. Judge, if people don't understand, the court reporter has more power than the judge, because when that goes out, the judge has to stop too. That's true. I know. That's why I always treat them with great respect. This sort of lost there for a second. You know, put it to the floor, and she's going to, they would say, is that she intentionally caused this recklessness. She intentionally wanted to go into the building. I don't know where that comes from. I have no idea. Yes, I understand what the video shows, but an intent to do that, that's insane. That's crazy, with all due respect. So then, while I'm working at my office and I'm going through things, we start getting voluminous records. And, you know, you were told it was, I don't know, I thought it was 200 pages, but he says more like 300 pages, you know, of going through all the records with the state of Michigan and their history and their certification, the machine, and this and that, and also all the records of acetone and all the other things that show up. And it's interesting that, and this is real pivotal part of the case, is you want that blood to be as pure as humanly possible for testing. Why? You got murder too, 2 charges. You have other charges that are extremely serious, under the influence causing serious injury. These are all very serious charges, very serious felonies. So you want everything right on the money, absolutely as perfect as human can be. So why would I not? Doesn't cost a penny, and you do it every day with drunk drivers. As a road patrol officer, why wouldn't you take him to the station, get a breathalyzer blown? It's also closer in time. Have that done. Doesn't cost anything. Then you got the data master, whatever they were using back then, the breathalyzer. Okay, you got those results, they print out. Right then and there, not an hour, right then and there, immediately when you're blowing. 2, to confirm the first. If they're too far off, a third. Why would you not want to do that? Number 1, you've got fatality. Okay? Number 2 is, why wouldn't you do, and he talked about, a urine test. I'm not saying you got to do one of those, but at least a breath test, but you could do a urine too. That's what the law says. That's what that DI 177 that he talked about, that he read, which means your right to refuse it, but you can take all these things. My client says, yes, sign. You don't even need a warrant. They got one anyway. I'll sign. You can take whatever blood you want for testing. Does somebody guilty do that? Does somebody feel guilty do that? Somebody's scared and they're under the influence, do you do that? And I'm talking about to be a 1A. Does somebody sign and say no? Or, yeah, go ahead and take my blood or my urine or whatever? No, I don't think so. Again, we can use our common sense on this. So they do that, and they wait, a couple days, and take it to Lansing. And then I'm very thankful they have a video of the person drawing the blood. And you know what? That speaks for itself. All of you saw that. And that's why there's 12 ultimately, because sometimes you catch something somebody else didn't catch or whatever and talk about it. And what's really great is you can ask for those videos from the bailiff to the judge for any of those videos. And they'll be, the judge put together a very nice exhibit list of the videos. So you don't have to look at all videos. You can pick out what you want to see, which is good. And so you'll be able to see, did she shake it? Did she invert it 8, 10 times? Because it doesn't cost anything to invert it more than once or twice. But I sort of, with all due respect, I sort of got the gist from her that she was okay with the prosecution, but if I started asking her anything, it sort of went downhill the attitude-wise. I don't know why, but I have no idea. I thought I treated her very nice. But it just seemed like she was not happy to be here anymore. And all I did was ask simple questions. But that's up to you to judge that, because you can judge credibility, attitude, truthfulness. You can do all that. That's what you are. And so when I started asking her, well, whatever, and she said a few times whatever, and then I said, well, the video showed 1 or 2, it was done. It wasn't even done like that. She said, yeah. Okay, so, sort of truth serum comes out when you tell somebody, well, there's a video and it says this. What do you think now? Well, yeah, it was 1 or 2 times. Okay. So that's done, and the preservative is extremely important. Why am I hitting this so much? Because that's their case.
Let's step aside quickly from these closing arguments to bring in our guest this hour. Trial attorney Megan Whiteside is with us. And Megan, our viewers may be wondering when they're hearing this defense attorney seem to be okay or understand the charges against her that are lower, the operating while impaired, while intoxicated and causing a death and injury. She's facing multiple counts, 2 for causing death and 15 for injuries. But it's 15 years if it causes a death, and if they find that it's above 0.17, that she was found to have been intoxicated, which she was, it could be argued that she gets up to 20 years for each of those 2 counts. Your thoughts on this approach by the defense?
Well, I think it's an interesting one. And the defense in his closing mentioned credibility. And this is where I think he's going with it. He's trying to seem like the most reasonable guy in the room. Now, the defendant has selected a very competent defense attorney, seemingly an everyman, someone who seems comfortable in that jurisdiction. And she's facing, as you said, very serious charges. And when you're talking about the death of 2 tender-age children in such a traumatic way, this is an emotionally charged case. And so if you shoot too high, saying we're disputing everything, the defense attorney is smart. That's going to anger jurors in the light of what we're dealing with here in this very emotionally charged case. And so what he's trying to do is say, look, we're admitting to all of these things. We're being reasonable. We're not fighting on every single thing in this case. However, we are fighting on where the government has not met their burden and where, in fact, he is trying to persuade this jury and motivate this jury to find a compromise verdict. Now, it was interesting some of the language he was using in the portion of the closing we were just watching, because he was trying to essentially increase, in my opinion, increase the government's burden on proving second-degree murder. He was talking a lot about intent, but if you look at the law in Michigan, second-degree murder, that burden can be met by a reckless disregard for human life. And I anticipate in the rebuttal closing, we're going to hear a lot about that. And so the defense is trying to take sort of a middle-of-the-road approach. Listen, we are admitting what we need to admit, and we're fighting on where the government hasn't met their burden. And in fact, that he is suggesting that she's innocent. Doesn't have to prove innocence. He just has to prove that the government hasn't met their burden. A really interesting approach.
Mm-hmm. Yeah, absolutely. But he does have that sort of feel to him, like, he's a nice guy, and it goes a long way in a courtroom to
really can.
at least keep the jurors' attention, whether or not they'll buy into it. We'll see. Let's get a break. We'll get more of the defense close, and then the prosecution rebuttal. Will they address the intent, as Megan predicts? We'll find out. Stay with us.
An Iowa man is found unconscious after crashing his car. He asked police to check on his girlfriend, recalling flashes of violence. Now he's on trial for her brutal murder.
The Visions of Violence murder trial. Live coverage today on Court TV. Tonight on Closing Arguments, a juror from Karen Reed's first trial speaks with Vinnie Politan, giving their first-hand insight on the case ahead of her retrial. Closing Arguments, tonight 8/7 Central, only on Court TV.
We're picking it up right where we left off with closing arguments in a case against a woman who is accused of driving her car into a boat club and killing 2 children celebrating a birthday party.
Prosecutors claim that 67-year-old Marshella Chidester was under the influence of alcohol when she crashed her vehicle into that party, killing 2 kids. The defense says she suffered from a medical condition that caused her leg to hit the accelerator, and it had nothing to do with alcohol. She'd only had 1 glass of wine.
And the crash killed 2 siblings, 4-year-old Zane and 8-year-old Alana Phillips. Over a dozen other people at that party were injured. Let's go back into court now. We're picking it up where we left off. The defense making the argument against those top charges of second-degree murder in this case.
That's why I said, why not take a breathalyzer? And that. Nobody says not to do blood. If you're going to do blood, do it correctly. It's very important. So it sounds like she does, like she said, hundreds or thousands or whatever it was, and she just, it's another day here, whatever. Well, there's 2 murder, 2 charges, by the way. So that's done. It's packaged, and it's driven up a couple days later, whatever it is, and it's tested. And testing it, and they agreed, the toxicologists or whatever, said, your test results are only as good as what you're testing. If it's polluted or it's not good, then your results are not good. Yes, they can come in all day long and give sworn testimony and say, it was a 0.18. I don't doubt that. I don't doubt that that was the result. But how did you get the result? Was there a problem with the fermentation? And something that really sticks out, other than, well, you didn't shake it, so there was fermentation, and here's Bill Colovos, he's coming up with something off the wall, that it's too many maybes there, and it won't overcome beyond a reasonable doubt. No. We've got proof positive. Very thankful that they have proof positive of a graft. I want you to take a look at, I believe it's Defendant's Exhibit C. I believe it's C. I only have 3. So take a look at that, and it'll show that it's more than a little bump. Take a look at it and see if it goes up like this. Acetone. That gas came out. And then they'd have you believe that the state of Michigan says it's okay to have acetone. It's all right, that commercial cleaner. A little bit of that doesn't hurt you. insane. I mean, come up with something better than that. But it's okay. Nobody gets hurt by that. Oh, okay. Have you done ever testing on live human beings with acetone? I don't expect they have, at least this generation. So acetone, and then my person, who to me came across very professional, very, in my opinion, you're the judging on the credibility of people, was sharp. He was credible. He wasn't sarcastic. No matter if the prosecution or myself asked questions, he was honest. And acetone, he said, you know, nail polish remover. That's what acetone it's made up of, industrial solvent. And what happens is nobody says anybody put that in the blood sample, but it occurs through fermentation. It occurs that way, or something was polluted. The needle, before it went in there, had something, a microbe or whatever. We don't know. But I don't care how it got there. It shouldn't be there. It shouldn't be there at all. And if it's there, it just spoiled the results. These results are supposed to be positive and clean and accurate. You know, accurate, in my opinion, you're the finders of fact. Accurate, in my opinion, accurate is out of 100%, if you can get it up to like 95. That's accurate. You start going below that, there's a problem there about accuracy. It's not a 51%. To me, that's not accurate. Okay? Again, we draw it back to murder 2. 2 charges of murder 2. And operating under the influence causing death. And operating under the influence of causing serious injuries. Counts there. Alcohol has to be right on the money. And I know I repeat a couple things that just because of the seriousness of this case, please excuse me. Where's the breathalyzer? Wouldn't have cost anything. Wouldn't have it been amazing if the breathalyzer said 0.01 or 0.02 and they're claiming 0.18? Boy, they'd have a lot of questions to answer. But you know what? The less testing you do, the less tests you have, the less defense attorneys have questions to. Right? Right. So we don't want to have too much. Plus, remember, they're the ones in charge. You can't say, you know what? I want to go here. I want to go to a doctor. I want to have this or that. You can't say that. Why didn't they have the hospital do it? She had insurance. Why didn't they have the hospital draw some blood? Just for the heck of it. They didn't have to worry about transportation, fermentation, nothing. Boom, it's done. Oh, by the way, I forgot about refrigeration. And it's supposed to be refrigerated. Might have an expiration date, but milk does too. And if you put it outside, not refrigerate, guess what? Who cares about the expiration date? It's spoiled. Spoiled milk is the fermented, and that's literally it causes curds and stuff. I left some too long in my office, and it stunk up the office and the refrigerator. Baking soda had to be put in. So you know, fermentation is a very strong animal. It's very strong, and it's aggressive, and you don't want that because you've got all these serious charges, including murder too. I want to know, if I was on a jury, that everything is properly done and there's no question whatsoever. And beyond a reasonable doubt, it's pretty close to that. That where we're at is that there's no question that it's there. All the elements are there. Everything was done properly. If things were not done properly, please don't feel that the seriousness of what occurred, I can't say not guilty. That's not fair. You know, that's not what the law says. The law says for you to do your job, do your duty as a citizen, as a sworn-in juror. And that is, if you feel that somebody's not guilty of all the elements and the people have not proven it beyond a reasonable doubt, all the elements crystal clear, then your duty is to say not guilty. And you say, oh my God, these people are going to be mad, or they're going to say this. No, you don't do that. In America, you rule, just like the judge has been ruling. He rules. You rule too when you deliberate. Please. Your decision is, your decision is going to affect my client's life. And I know by looking at all of you, and I've had a few trials over the years, that you've taken this very, very serious. Very serious. And I truly mean that, or else I wouldn't say it. I've had a few juries, and actually, honest to God, some people will start nodding out. They'll start going to sleep. And it's like, I got to speak real loud to wake them back up from over here. And that's sad. That's really sad. And this was supposed to be a long trial initially. You know, picking a jury, you don't know if it's going to be 3 hours or 3 days. And we moved along very well. And everybody came across very honest. And I think that's how we were able to do it. Plus, the judge is really good, if you haven't noticed, about keeping us reined in and moving the case along. I love that he starts at 8 o'clock, because I've been in other courts that say 8:30, and they show up at 11, the judge. So this one I can count on. That door's going to open at 8. And that's good, because it's taken a lot of time out of all of our lives, but more importantly, we do this for a living, out of your life. And I truly want to say thank you. And I truly say thank you for being here, for uprooting your whole lives. I don't care if people are retired at home, you're still uprooting your life. And lastly is that we've put such a heavy burden on you. We have a very heavy burden on you when you make your decision. However you make your decision, I will respect it. But you've got a heavy burden, and everybody has to go on living. But I want to thank you again for taking the time out to be here. There's areas I didn't cover just because you listened to everything. You saw everything, the testimony, videos, exhibits. So I'm not going to go through every single piece. I've gone through enough, but it's my one time. I don't get a second time. If he does go up, Mr. Lorraine or whomever, please try to think what Bill Colovos or the defense would say in counter it. Okay. Thank you very much again. I appreciate your time today.
Thank you, counsel. Brief rebuttal. Absolutely.